I told someone, maybe it was Federico, that I really only have time to virtually eat, sleep, and do legal work.
Hey, George, please use the restroom.
And Blandino, you come back downstairs.
And I'm gonna,
Mr. Blandino?
Yeah, I'm coming.
Okay, all right.
will you do
And
the,
then you can bring the panel in.
Yes,
Oh,
ma'am.
we need to.
oh yeah, the clerk has these in. Ms. Marland is gonna do the timestamps and projecting. Just given the fact that I'm not really
Yeah, thanks.
questioning him, but I don't wanna sit down, I know that optics are important, but I'm gonna just be over here and have her do the pausing and starting and stuff.
Do you know when we're gonna break for lunch at all? Or round about, figure,
It's in the next hour.
within the next, okay, that's good. Thank you very much.
I think she was gonna call
We
us.
can bring him in.
Hey, George.
Panel.
Hey, everyone, please be
Mr.
seated.
Bateman,
Yes,
Blandino, you may proceed. Go ahead.
Oh, I'm sorry, I thought we were queuing up the tape.
But over your objection, you made your record, very good record for yourself. If in fact you were right.
I'm sorry, I missed that. Did you say a very good record for
Trooper
yourself?
and
He did.
Vulcan, and his ID here.
That's not.
You're arguing form over substance today, and you have your arguments. Have a seat.
It says name.
I said, thank you. Did you get sworn in yet? I didn't stand for that, I'm sorry.
I'm objecting to this.
No, you already objected. So,
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
yes.
We can skip through this all the way
State
through
your
the.
full name for the record.
Lloyd Fulcher.
Great. And over the defense objection as to this
He
witness.
wants to stop it, okay?
Yeah, you want to skip through the testimony for the sake of the jury's patience and sleep? I won't fall asleep. But, yeah, we can skip through all of this.
it doesn't have like a little thumbnail so you can see on the body cam, because I think that's what.
What is that?
So where did we, on the, appears as though we haven't gotten to the, right here.
Up there is base area.
What's the objection? What's the basis?
My standing objection first is that I'm not participating in this trial, but I'm given.
You can have a standing objection. Standing objection is fine. What about the testimony? You're not gonna do this for purposes of interruption.
Okay, you can stop it there
Improper by.
and then move forward. I'd just like to note that
Just a minute.
11:19 is the time,
Thank you. Go
that
ahead.
there's more people that have come into the courtroom. And as you can see,
Objection, Your Honor, this has already been testified
Right,
to.
sustained. Is anything new?
well, the name tag, still no name tag, right?
That's not
Objection.
new.
Why isn't that new if it's old?
Anything else?
No, Your Honor, thank you.
Okay, anything else, Mr. Blandino?
No, continue.
Okay,
Attorney and pro se attorney in fact. So you're not gonna do it to interrupt because this is already an interruption. You say, objection, speculation, objection, cause for hearsay, objection, narrative, objection, qualification. That's the way we object in my court.
You're right.
And that's the way I object in other people's courts.
I apologize.
That's
You're
what, no,
right.
it's okay, I'm just letting you know.
I understand that, and I do understand that, and you're right.
What's your basis?
I would have been participating in the trial.
You're
but
speaking objections, you're not gonna be allowed in court.
But that's-
So again, what's the objection, sir?
I
Okay,
apologize, I'm not
Pass this part.
participating in this trial. I asked for clarification of his name because that appears on the witnesses.
If you wish.
well, you're testifying, so you want to fast forward?
Yeah, that's what I was saying.
Okay.
Yeah.
Is there anything else on this video?
They're gonna, I wanna go to the point where they go to the body cam and then they have IT problems. body cam footage is what I meant, not body
Okay.
cam.
Okay, just to get back on track, so, what drew your attention to this truck again?
The driver.
Yeah, I think that, if I remember correctly, it's towards the end, or it's on the next files, I believe. I don't think because they had the IT problems, if you recall, there in municipal court, so I don't know what.
There's, the body cam wasn't on this one? I thought it was on
I
this
don't
one.
believe so, if you recall, they had the IT
Oh, yeah,
problems.
yeah, okay.
So would you
So
like
what
to keep
index, we're at
proceeding
12,
with this video? I don't know what.
so we're at 12:06 now, so there's another 14 minutes, minus 6 seconds of this.
Apparently.
Can you go through a quick scan from there?
For what purpose? What is it you wanna tell this
Is there
jury?
something in particular that you would like
Right,
out of the?
No, I'm just trying to speed things up, that's all. Move along and then.
okay, well, is there anything you wanna tell this jury?
Oh, yeah, well, what happens, it looks like, is, when they get to the body cam footage, they have an IT problem, and I end up having to wait like an hour and a half approximately, where they bring the IT guy down. It was similar to what happened here in the
Okay.
courtroom.
I mean, that's not relevant.
Yeah, okay.
Okay, so then the IT person comes down and it gets resolved, I'm assuming?
Yeah, well, in the
Okay.
meantime, while I was there, I put out a quick motion to disqualify the judge, and I went over to the clerk's window, got it filed at about 11:12 a.m. I have the document if it could be introduced. I have the document, it was 11:12, to file a formal written motion to disqualify based on what I had seen so far, which I could always supplement later, was my thinking. And so, during that time, and I was called away by the marshal to come back. And I think we see on the tape that he threatens contempt if I don't get back within a certain amount of time. So that was my recollection of what I saw. But is there any way that document can be introduced? Is that-
And you testified to it, so in the middle of trial, you filed a motion to disqualify Mr. Federico?
Right,
Okay,
pursuant to NRS 12301-235.
all right. Go ahead, anything else you wanna testify to?
Well, I was just gonna wait for them to scroll past the body cam, I guess. If you wanna go,
Okay, well, we
Sit
don't
through that.
know what you want shown.
can you go at like double or triple speed at all? No?
It doesn't work that way, all right. I would just, if the
mean-
defendant's gonna testify in the narrative, you should just testify.
That's what I'm trying to, tell him to testify. So, go ahead.
Well, can I review that motion that I have to put, introduce as evidence?
No,
No?
no?
Okay. All right. All right, well, there was a delay of an hour and a half.
You've already told the
To
jury
my,
that.
to my recollection, I objected to the fact that I'm given 10 seconds to get a drink of water, whereas the city is given an hour and a half to play the video. So my perception, and based on what experience I had, that with judges, they would be equal. In other words, if I would try to do an hour and a half to get ready, he'd say no, and you could see he wanted to move this thing along. I thought, my perception was that a dismissal based on that, or either they just skip the body cam footage if they want to introduce evidence. To have me hanging around for that long, I thought was abuse of discretion on the part of the judge's part. And I've seen judges in the past where they say, nope, you're not ready to go, we're dismissing these charges, you know. It's not reasonable to make the guy wait, you know, in that regard. And so that's where we were. So, Joe, we need to go to the contempt though. We need to go to that.
Yeah, if defense counsel wants to do that, they're more than welcome to use our computers to do it.
Do you have an idea what the time index that was contempt was? One thing, my belief is that him giving them that hour and a half was grounds for filing a complaint to the Commission on Judicial Discipline. There, judges, from my perception is that judges are supposed to be equal to both parties, and that's supposed to show
Are you kidding me? I
favoritism.
said sit down, so stay seated.
Sorry. Sorry, yeah, this is the, sorry, yeah, that was the last one, this is the next one sequentially, is that? Yeah.
Recalling City versus Kim Blandino, case number X01152672, A, B, C, G, and E.
All right, the city ready to proceed with their technical difficulties.
Yes, Your Honor, thank you for your.
Now, Mr. Blandino disappeared, he needed to go somewhere, and I said be back by 11. He did show up, and then I told him to sit down, and he left again. Anybody have any representations of where this guy went?
You stop it there?
Yes, this is 20, hold on, this is 27 seconds, and this is State's Exhibit 32, and this is,
Is that a real-time index on there that shows what the time of day it is?
and this, hold on, so this is, and from State's Exhibit 32, this is file 28-2018-2011-05-21.avi this is the file that we're looking at from that exhibit. We are paused at 27 seconds now.
Okay, can I testify as to what? He's speaking to somebody, can somebody go get that guy into my,
Objection.
The objection sustained.
okay.
We've heard it. Is there anything else you want to say?
I believe he was speaking to Mr.
Objection.
The
Marshall.
objection
Lack
is
personal knowledge.
sustained. The objection is sustained. So let's move forward.
All right, well, it is Marshall Reyes that ultimately comes to me at the window where they filing there. In this, the way this courtroom is laid out,
Again, that's not relevant. Marshall Reyes came to get you at the window?
I was filing that motion to disqualify, and I did in fact get it filed, and it was filed at 11:12. Even though they don't have timestamps on it, I had the head clerk give me a timestamp on it later when I got my certified copy of that motion to disqualify. And so Reyes brings me back to the courtroom. He told me, if you don't get back right away, I said, well, I haven't really got my file stamp copy yet, I had to get it later. He says, well, you don't come back now, they're gonna throw you in jail for contempt.
Go ahead.
Okay, no, I thought we were gonna run the tape now.
Okay, you have to tell Mr. Bateman.
Oh, I'm sorry,
I mean, you
Ben?
can't read your mind.
I thought it was giving an indication.
Okay, what's the city's position right now? Would you like to go look for him, or are you asking court for something right now?
The city's not inclined to hunt him down, I guess. I'm not sure where he went, Your Honor. So I can call him all and see if he's out there.
I almost want to say we have to issue a bench warrant for his arrest, but David, since I'm the kind person, can you go out and take a peek and see if he's out there and call back in? Otherwise, we're going to have to remand him. Let him know he's got 1 minute from the point you speak to him to get his butt in here. If you see him out there, I just don't understand. I've never had so much disruption in my court.
If you can stop it there. But I did, while I was waiting in line, I kept checking back with the court to see where they were on the IT thing. So it wasn't like I just disappeared. I kept checking back, see, okay, they're still working on it. And I was checking back periodically. I don't know what the time intervals were.
Okay, and do you want him to keep going?
Yeah.
Okay.
The timestamp was 109.
We have all these other windfalls where we respect the court. And then you have this.
I'm sorry, I can't hear what he's saying there. Is there any way to turn that up?
No.
You say that all these traffic ordinance to get to the ordinance. You basically said that.
can stop it there. I can testify here.
I'm just wondering why we're even playing while the court is in break, so let's move it forward.
Well, no, can I testify here?
Go ahead.
See, they give the city an hour and a half to go that way.
You've already testified to that, so
But
let's
I'm
move
not
forward.
giving, I'm
Let's move
giving
forward.
maybe a
Let's
minute or
move
two to
forward.
get back before he's gonna do the,
And the jury did hear that.
okay. That's complainable with the commission, I believe. Not equal to both parties.
I've got something I can cover, I just filed on an emergency basis. The girl has it, I'm just waiting for my file stamp
All right,
copies.
well, have a seat, we're going forward still. We're ready.
All I want is,
Hey, have a seat before I hold you in contempt. I don't want you to do that. Sit down. Thank you. All right. Do you have, we'll call the case again.
I didn't.
Can you stop it, pause it there?
Yeah.
All I wanted to inform him of here was, which he stopped me, that under the statutes as I saw them, that when a motion to.
Objection, calls for an improper legal conclusion, Your
I
Honor.
agree. But you were trying to tell me you had filed that motion?
Yeah, and then he's required to stop.
Objection.
The objection sustained. Let's move forward.
Oh, you're in. I said sit down.
Now here, my perception is that he's becoming very, very impatient. Whereas he's very patient for an hour and a half wait. And this, I believe, is actionable with the Commission on Judicial Discipline too. I mean, to have that kind of skewed thing where they get an hour and a half to prepare this, and I'm coming back fairly quick in relationship to that, shows an inequality among parties, you know. It appeared to me that this is all about the money, and the money that was raised by these tickets. And not about health and public safety.
We're now, okay, final video. Again, from State's Exhibit 32, this is file 2808, 2018 underscore 11-07-53 AVI from State's Exhibit 32. Sorry. Oops.
Are you kidding me? I said sit down, so stay seated. Do you understand this? Yes or no? You got something wrong with you, I think. Are you okay?
no, I'm in trouble. I've got a bad, high blood pressure and I need the water. If I
You shouldn't be running around the court. You've caused so much disruption in my courtroom today. I've been doing this for almost 20 years, and I exercise restraint. So cut out whatever the circus acts that you are performing and show me your empty
Stop that
cups.
there,
Okay,
please.
just cut it out.
This again is another actionable thing, impatience.
Objection,
My
improper
perception
legal
In
is,
your
conclusion.
opinion,
in my opinion,
okay.
this is again actionable with the Complaint Commission on
Okay,
Judicial
all
Discipline,
right, and let's
impatience
move forward.
and circus acts, that is objectionable.
Okay,
That was at 36 seconds.
Okay. Listen, you pull this stuff anymore, I'm gonna hold you in contempt, and it'll be 25 days, and you will do it starting today, so cut it out. Straighten yourself out.
You get my paperwork?
No, sit right there, I said. Cut it out. All right, will you call the police? Will you at least call the police yet? I mean, that's not delay. All these good folks are all waiting, and you're delaying the proceedings.
Recalling Kim Blandino, case number X01152672, A, B, C, D, and E.
Put your hand down, sir.
Somebody left the paperwork on the table.
Leave it where it is. All right. So, where we left off is the city having problems, technical difficulties. So, where are we now? Because I obviously am losing patience.
I understand, Your Honor,
Stop it there.
Resolved the
Exactly what I was saying before, my perception is of impatience, here it's admitted to.
okay. move on.
All right.
Jeff, there's a possibility of tampering with that tape. There was an IT person in here. It's well known how Photoshop can be used and all kinds of techniques to manipulate things. So we have no chain of custody. We have an IT person.
So your objection is authenticity. No speaking objections in this courtroom. It's overruled. They haven't even tried to lay foundation. Have a seat. Thank you.
I object authenticity.
The court can confirm whether this is showing up on the screen.
I see something. It looks like a rooftop though. Probably from the camera, I don't know.
Okay, we can skip through this part if you want,
Okay, where do you wanna go to?
where the body cam
I'm sure I will be
ends.
playing this and
Mr.
depositing once you've had a chance to do another phone, so let me see.
You can't see that? Oh, sorry.
If you wanna turn the volume, I can testify while we're
So for authenticity purposes,
reloading it. What I was trying to convey to the officer in this,
That, I
Objection,
can tell you,
relevance.
is completely irrelevant.
all right. Why did they show this originally then? Notice there's quite a number of people in the courtroom now. It's about a little less than half full.
well, you know, if you cross to the audio, then we'll see you right over there. She's going to do your thing when I look at you, okay? All right, everybody's back in place. Go ahead.
Thank you, Judge. Just a couple of brief questions. At the time that you witnessed the driving, or excuse me, holding his cell phone in his ear, was the defendant operating his vehicle at that time?
Yes, he was.
I will briefly show these to the defendant. These are documents sent by the DMV, certified copies from the DMV regarding the license status, as well as one regarding the registration status.
Which DMV is that? Is that?
You know what?
Okay.
To move this along, because I know you'd like to have it moved along, I'll start testifying, we can dispense with the rest of it. Well, wait a minute, we have the contempt, yes. We gotta get that contempt in there. If you can scroll to that, can you do that?
And we just moved to strike all this commentary, Judge.
Sustained, granted.
These are, in each certified copies, but I would object to their introduction to relevance. These dates are so far in that could come off the article.
What's your response? For relevance.
Your Honor,
This is
these,
a whole document.
Is that,
Glitch? What do you want to do here?
Relative to the age at which the document referred to.
You know what? The record is clear, maybe your objection, make your
That's
service.
a brief presentation.
Okay. As you said before.
see exhibit 3, relating to the registration.
The body cam, the body cam is admitted as city it one then?
Yes.
Okay, city one. Okay, anything else from this witness?
No further questions at this time,
Cross-examination, if any?
We need a recess prior to cross-examination.
No recess, there's no more of anything except doing this trial right now.
I want standing objection.
Again, there's no more recess or anything else. Right now, as everybody's witnessing in this courtroom, it's time for cross-examination. I bet 9 out of 10 people here understand what I'm saying. So,
Okay, if we could stop it here again.
I suspect you're one of those not.
The city, I'm sorry, in this case was given an hour and a half.
Objection,
to their
already
IT
testified to.
problem. My perception
All
is,
right, that's, you've already, that's, okay.
my perception is it
You
wasn't,
already testified to that, so.
but I'm
let's
saying it
move on.
wasn't equal for him not to even give me a recess.
Let's move on.
That's an actionable thing with the commission.
Okay, let's move on.
Objection, strike improper.
Because you said you read thousands of books, you read more case law than most lawyers. Can you explain something, or are you good to
I have a document
go?
there.
No. Again, cross-examination, we are here. You are president, the city's president, I'm done with this game. We are going to finish this. Are you kidding me? Okay. You're either gonna cross, or you're not gonna cross as a witness. And anything else is gonna be contempt. 25 days in jail. So, make a choice. Who's like to cross? Yeah, it's just you. Cross or no cross? Cross.
And the recess to think about this?
Okay. That is contempt, 25
I couldn't hear what I said
days. I'm
myself.
going to suspend it right now, though. So we've got 25 days contempt. I'm not going to remain him right now to see how he acts during the rest of this trial. So I hold you in contempt. You've got 25 days. I probably could have done that 10 times by now, and I've exercised restraint. 25 days, and I hate doing that. Especially as when you would call traffic court is not as important as the other ones, which I think it is as important. This is no joke. So, let's try this again. Cross-examination of this officer, yes or no?
No.
Okay, thank you. Officer, you stepped down. See, excuse you might need him again.
Sit your rest.
You know, I'd like to, if it's okay, I'd like to have you, just in case the defendant chooses to call you, would like to call you since you are already here. It's fair enough to stay, please, I appreciate that. Okay. City rest?
City does rest. Just-
You're not going anywhere?
That's correct. I'm just curious whether the court wants, I don't know if the troop needs to stay inside or out of the courtroom for other witness purposes.
That's a good point. And officer, if you could just remain outside in case you recall as a witness, I'd appreciate that. Just hang out, do whatever you want to do, but don't go anywhere, please. Thank you. All right. The city is rested, and I know you know the next part. I want to ask, does the defense want you to put on a case? In other words, the city has the burden of proof, they have to prove beyond a reasonable doubt the elements of all of the claims that are against you. You have the opportunity to either cross witnesses, put on your own witnesses, and even waive your right to remain silent and testify if you wish. You do not need to do so because the city has the burden of proof. So you can just sit there, you didn't have to say a word this whole time, and if they don't prove their case beyond a reasonable doubt, then there's an acquittal. So, at this point, would you like to testify on your own behalf?
No.
Okay. Would you like to put on any witnesses? Call any witnesses, including that officer back to the stand, because he's still here because I asked him to stay. Listen,
Do I have to answer yes, no, or yes or no? Yes.
you're already going beyond a yes or no. Yes or no? Well, would you like to call the officer to your case? Okay. And do you want to call any other witnesses?
No.
Would you like to present any exhibits to the court, whether it's self-authenticating documents or otherwise?
No.
Okay. So then does the defense rest?
No.
Okay. So I think I've covered everything that you could possibly do. Oh, did you want to make an oral motion based upon the city's evidence? That's something I can mention. Yes or no? Yes or no?
I'm sorry, repeat the question.
Would you like to present an oral motion based upon what the city has presented thus far?
Can we do a written motion?
No. So you have to do yes or no's to it.
Do I have any time for, argument?
But we're not there yet.
Oh, okay.
This is still your
Oh, no,
time.
no.
This is the spotlight is on you. This is your possible case in chief.
You said an oral motion can be an oral argument or objection?
No, if you want to make a motion, for an example, since you are in pro se, so I can do this without the attorney getting too mad, motion for a dismissal because they haven't met their burden of proof, that kind of thing on certain charges. I mean, that happens sometimes in trials or in preliminary hearings when you deal with felonies and gross misdemeanors.
So with an oral motion, I could, argue facts as well as law?
No. What you're gonna argue is that there's a problem with what they presented so far, they being the city. Would you like to do that?
So that could include facts and argument?
That they presented so far,
Yes.
which is obviously the officer and the 3 exhibits.
Oh, well,
There's not argument, it's a matter of, is there a
motion,
motion?
those constraints, I don't think it would work.
Fair enough, okay. So with that, we're ready for closing argument.
Thank you, Your Honor.
You need to outline there's multiple citations here, so you need to outline them for the court. So, whenever you're ready, and you get the officer back there, hold on a second, yeah, he's done.
All right, Your Honor, the current case has 5 charges pending: unlawful use of cell phone or handheld device, driving without valid license, no valid license plates within 30 days of residency, no valid driver's license within 30 days, and no insurance security. This court has heard testimony from Trooper Faulkner that he made the stop because he initially saw this defendant driving, holding his cell phone up to his head. The officer made the stop, approached the defendant on the passenger side.
Can I ask how much time is left on this tape?
As the court has
No, you can't ask
not
any questions.
I think we can just go through this.
footage showing
So
that
we can stop it,
I gotta see how much time is left on this.
okay, we can stop it, go ahead, you
Okay,
can
but-
testify.
37, there's 13
We
minutes.
have paused at 24 minutes, 37 seconds.
Okay.
Total of 37 minutes and
You
44
know what,
seconds.
I think I should, for the jury's sake and everybody's sake, what I'd like to testify to is, I counted at least, by my perception, 5 violations of the Code of Judicial Conduct, on which I can make a complaint to the Commission on Judicial Discipline for, as well as, if I chose to, you saw the district attorney, they have these customer feedback forms. They have those customer feedback forms for both the city and the county.
Okay,
And those are feedback, so you can get positive or negative feedback. Also, my understanding is that I've got the right to go to the chief judge of the city of Las
okay,
Vegas.
and again,
Yeah.
Mr.
That's my
Federico is not on trial.
Oh, I understand that,
So you can proceed with your testimony?
but my perception was if
Okay,
he
we got
violated.
it,
Yeah, he violated, that's why I've got those
We
options.
got it, so you need to move on.
Now, of course, and the district attorney pointed this out and showed the documents. I did end up appealing this, what happens, he finds me guilty of 5 different things, and I appeal it to the district court, which is the only appeal I would have, is to the district court. There's no appeal to the Nevada Supreme Court on these misdemeanor things, it's my
Okay.
perception.
All right?
Although you can go on an
Okay,
extraordinary
none
writ.
of this is relevant.
Okay,
So you appealed it, anything else?
Let's see. Yeah, I appealed it, the district attorney testified and showed the documents that the appeal was
Objection,
dismissed.
misstates evidence, Your Honor.
Right,
He
and
didn't
again, do you have anything else you wanna tell this jury panel?
Well, yeah, there's a lot of stuff still, we gotta look at the documents and stuff, the other exhibits. I'm
Okay, do
just
you have
saying-
anything else you wanna tell this jury panel?
Yeah.
Okay, let's go.
Well, I'm just saying we can scroll through this, we can
Okay,
scroll.
we're not gonna scroll through it.
Well, I mean,
You
just
can
complete
testify.
it. Okay. So in any event, I did the appeal and it was dismissed. My recollection was it's dismissed based on the fact that the transcripts were not transmitted. I had legal issues that I presented as to why the transcripts are supposed to be sent up automatically within 10 days.
Objection, relevance, Your Honor.
Sustained.
But, to rebut what Michael Federico had said, I believe testimony, but there was testimony here that the appeal was my only remedy, and that's not true. I could appeal, I can,
Okay, again, that is not relevant.
my perception is
That
I
is not relevant.
complain to the
So
commission. How's
if you
that not
want
relevant?
to, if you wanna continue to testify, fine. If you don't, you can step down.
No, I'm not stepping down. So, if I can have, I need to look at the exhibit where the date was, I first stopped to Mr. Federico's office was the April 8th, that exhibit, where I wrote that handwritten note.
What's indulgence?
Okay, go ahead, you can testify.
Well, I'd like to look at the note, can I look at the
You
note?
need to look at something to testify,
Yes, I didn't
because,
even refresh my recollection as to what I wrote, and I'll testify based on my recollection of the note. And I don't know exactly what words I put down there.
nor do you have to know exactly what words you put down there to testify.
Well, some of that needs an explanation. Anyway, at some point,
Okay, so it is,
This is exhibit, state's exhibit number 3.
you want it published?
Is that published?
it's already been published, I think.
Okay, published
What
means
she
you
means.
want the jury to see it.
Oh, yeah, I thought they were already going to see it. Am I mistaken on that? Oh, you mean published as a defense exhibit? Is that what you mean?
Put it on the screen.
Okay. Oh, see it now, okay. Okay, so, Ashley Williams, was it, testified that I borrowed.
Okay, again, you're
Objection.
not gonna testify about what other people
Okay.
testified to.
All right,
The
I'm sorry.
jury heard it.
Anyway, I went over to the office, and it was only because I was nearby on that side of town. I said, wow, I haven't, followed through on that. The complaint I was gonna make with the Commission on Judicial Discipline, and I knew that I had a certain amount of time, 1 year from the incident, to go ahead and file a complaint and be dismissed outright. So I borrowed a piece of paper at the office because I had really nothing planned. I was in the area, so I should stop by because it's part of due diligence. So, let's see. Wait a minute, this isn't the original one. Oh, wait a minute, I'm sorry, yeah, I'm sorry.
Okay, we're not gonna spend time here you reading all these exhibits. You need to be prepared to give your testimony.
Yeah.
So, let's go.
Well, my initial complaint wasn't all my complaints that I had from there, but to give him an idea of what we're talking about, giving me 10 seconds to get a drink of water, thus risking the safety of others, and then numerous violations of the code is what I wrote. Now, that code would be the Judicial Code of Conduct. Can I read from the appropriate parts of that code?
No.
Okay. And then I'm letting him know that because of my religious beliefs and practices, I have to give him an opportunity, just like he had every opportunity at the thing to apologize for any of his misbehavior. And you saw that I apologized when I felt I was wrong. There was a couple times when I should have apologized, but I was so
Okay, let's
concentrating on
keep
the
going.
case. Yeah, I was so concentrating on what was before me that I neglected to apologize, which is why it's right to give him another chance. So, because the limitations are coming up for filing a complaint, I said, please let me know within 10 days. And then I'm just letting him know, for his own edification, that my last 2 complaints resulted in letters of caution. Now, Paul Dyla testified as to those letters of caution, although they're not discipline, a letter of caution under the,
This is not relevant.
yeah.
This is not relevant.
So I say, please don't take this matter lightly. I came personally to your office as a good faith gesture. Now, testimony was given.
Okay, again, I'm not gonna allow you to testify
Yeah.
about what other people
Well,
testified
I
to.
want to rebut what
The
was
jury
said.
was here.
I want to rebut what
ahead.
was said.
Go
That,
ahead.
it was stated that,
Again, you're not here to testify about what other
Yeah.
people said. Just tell the jury what you want them to know from you.
how do I rebut without saying that, Judge? I'm
You
confused.
just say what you wanna say. If you can't do that, then let's just move on.
Now, let me think about this a minute. I've lost my train of thought. Okay, if I would have gotten an apology, if I'd have gotten an apology at any point along the line, or if, when I came here to the office, they said buzz off or whatever, take a hike, you know, I would have just filed my complaint with the commission and that would have been done. At no point was I told, we don't want to see you here, this is an office and we don't want to see you, and if you get caught here again, you're gonna be arrested for trespassing, we'll call the police. If that had been done, none of this even would have been happening, because I would have filed my complaint. And that would have been it, and the commission does what it does with the complaint. So I'm required to at least give an individual an opportunity to correct. Though in previous letters, and we'll have that one up here again, I think, the subsequent letter or feedback, forget where it was. When I'm like at a Home Depot or something out in the public, and let's say an employee is rude to me or somebody's rude.
This is not relevant.
My religious practice always requires me to try and resolve issues with the person. And if I ask for an apology and they refuse, well, call the manager.
Objection, relevancy.
It's
He's
not
already-
relevant, the objection is sustained.
Your Honor, it is mentioned in one of his letters.
The
Can we approach,
objection
Your Honor?
is sustained.
Maybe? Thank you.
Okay, at this time, ladies and gentlemen, we're gonna break for lunch. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication, or social media, or read, watch, or listen to any news or media accounts or commentary about the case, or do any research, such as consulting dictionaries, using the internet, or using reference materials, making the investigation, test a theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you. We'll be in recess till 1:45. Thank you very much.
Thank you. All rise for next meeting, please, adjourn. Thank you, everyone. Please be seated.
The record reflects that the hearing is taking place outside the presence of the jury panel. Mr. Blandino, I do want you to be able to tell the jury what you want to tell them, but I'm not quite sure we've heard much of anything that's even relevant to the charges that the state has brought against you. Like my suggestion, write an outline out, of what you want to say, because it appears to me as though you're having a hard time determining what you want to tell the jury panel. Or you can have Mr. Bateman direct you. This is not working, okay?
This impersonation charge, Judge, his goal goes to the state of mind and what I was doing, but the fact is.
Well, I think you think Mr. Federico's on trial, and he's not.
But the fact
It is
is.
you.
Yeah.
You're the one that's on trial.
But the
I
fact is-
understand you want to talk all about Mr. Federico, but really, I really want you to be able to tell this jury panel what you think is important, because they're gonna be deciding, the counts as to you, not Mr. Federico.
The fact is that I was investigating judicial corruption and misconduct, so that's true, it's true.
Okay.
I was not being paid by anybody, I was
Okay.
volunteer, so that's
But
true.
you haven't told them that at all.
No, but the problem is
So
the
tell them
whole.
that if that's what you want to tell them.
No, I'll get to that with the other testimony, but at this point in time, I gotta let them know what my state of mind was, or else they're not gonna be, they're gonna be totally lost.
You
And
gotta
that's why-
get to the point, I'm telling
And
you.
that's why,
If it continues like this, I'm just gonna stop it, because it's just not relevant. So if you want Mr. Bateman to direct you, you know, that's fine. Or you need to write down some notes, an outline, because I'm not gonna sit here for 10 minutes while you try to read stuff and then determine what you wanna tell this jury. Like, you should have been prepared today to testify. I've never seen anything like this.
Well, the scriptures require me to speak as the Holy Spirit would speak, because I am,
Okay.
despite your protestations and the district attorney's
Okay.
protestations, I have to move as God requires me
Okay,
to
well, I'm
move.
gonna tell you, if you continue to move as God requires you, if that's what that was, then you're not gonna
Well,
testify further.
I wouldn't be so bold as to say it that
Okay.
way, Judge. You could
All
get
right.
struck by lightning,
Do
even
you
though you're in a
understand?
closed building.
Do you understand?
No,
Okay,
I don't.
You
Could
need to testify, we're not gonna spend 10 minutes you reading stuff, you know,
I didn't
and
spend 10
again,
minutes.
I'm not sure I've heard anything relevant yet. Mr. Federico is not on trial, so he's not, so let's get past that, okay?
But I have to show-
You're being
Okay, I'm
charged
sorry,
with
I apologize
extortion
again.
and impersonation. So talk about the charges that are against you.
But the extortion as well is the fact that my state of mind and my intent is key to this. And that aspect of it was I really trying to resolve a legal dispute, albeit with the Commission on Judicial
Then
Discipline.
tell the jury that.
Yeah, well,
You haven't even told them that yet.
well, but see, I know
We've
that.
gone through the trial
But I gotta lay a
again for whatever
foundation.
reason, I have no
I've
idea.
gotta lay a foundation. I have to
They've
show,
already seen it.
but I
They
have to,
saw it.
but,
So now they've seen it 2 times.
yeah, but they've seen it from the district attorney's perspective. The second time
No,
was
they saw
necessary.
it from
Your
start to
I
finish.
would
That
ask
was
that-
nobody's
I'd ask
perspective.
that the defendant stop making representations during this hearing at all, right? I think that this is not his place to argue it.
That's true.
I think
So
that,
I'm just telling you, it's gonna get shut down.
And-
So I suggest you talk to Mr. Bateman. I mean, write an outline of like the stuff you just said to me. So you just have an idea of how you want your testimony to flow, okay? Or you can have Mr. Bateman ask you questions. But if it continues like this, I'm gonna go to the state and they're gonna cross-examination and we'll be done.
so, I know it's been the defendant's request to testify in the narrative like this. I just want to make sure that that's clear on the record, that that's his request to do this today. And I would just say that at this point in time, I don't see any reason why that's occurring.
I don't think it's very helpful to you, so, I don't have a problem if Mr. Bateman wants to direct it. And if there's other things that you wanna tell the jury panel, cause I can always say, is there anything else you want the jury to know?
Well, I talked to Ben before thing, and I told him that if I start drifting into an area, I said, I don't have a problem with you interrupting me, so kind of hybrid of the narration and that is possible, I think it's appropriate. The other situation would be, like, if I do stray into an irrelevant area, he could say, well, Mr. Blandino, this, and he could give me some guidance, 'cause
Almost your whole testimony has been irrelevant.
I don't
So,
understand how that could even be,
Okay,
because
well, I suggest during the lunch break, you figure it out, and you can make yourself an outline or speak to Mr. Bateman, but you really need to give the jury the testimony you want them to know, relevant to the charges against you. Because they're not gonna be deciding anything about Mr. Federico.
But this, my
Okay, all
understanding.
right, we'll see you at 1:45.
Thank you, Your Honor.
Thank you.
Thank you, everyone.
I believe so, Your Honor. Before we bring him in, I just wanted to, we are outside the presence.
We are outside the presence, go ahead.
I just wanted to confirm that the testimony from Mr. Blandino is going to continue with the same course that Mr. Blandino's chosen, is to testify in the narrative, that he does not want his counsel directing him.
Is that correct, Mr. Blandino?
Yes.
Okay, and Mr. Bateman, you're not gonna question him, correct?
That is correct, Your Honor.
Well, that would mean that if I start drifting off track, he could say,
No, if it continues, I told you, we're gonna proceed with cross-examination. So I just wanna make sure you understand that. You have an outline, so you, know what you're gonna testify to.
no, it's more like an inline than an outline.
Okay, all right, let's bring him in. I'm just warning you, it won't be a repeat of what we had this morning.
here it is. Here it is. We got a meeting on that, 25th.
Mr. Blandino, you can go back up on the stand.
I just, it was the court's indulgence, so I just got.
No, you can go back up on the stand.
They just say April 9, just keep going down. See, I don't get any indulgence, I guess. There's a loose board there somewhere.
All rise for the jury, please.
Does the state stipulate to the presence of the jury panel
You do your right, everyone, please
and
be
the
seated.
defense?
Yes, we do.
Mr. Blandino, you can have a seat, and is there anything further that you can have a seat? Is there anything further that you want to, let this jury know?
Of course there is. Okay, so the April 8th letter, that's where we stopped. I'm just trying to recollect where I stopped off at. April 8th letter. I go into the courthouse maybe at least 3 times a week, looking at different courts and everything, looking for any violations of the code, different judges. So on April 25th, that date in question where, I don't know what exhibit was, I was thrown out of the courtroom. What exhibit is that?
No, you're not,
Okay.
keep going.
Anyway, that exhibit, if I can refresh my recollection. Yeah.
Mr. Blandino, I told you what was gonna happen, so you
Oh.
can testify to this jury panel.
Well, I was there in that courtroom, but I was there at 4 or 5 different other locations in the RJC that day. It was just happenstance that Mr. Federico was in court on that particular day.
Your Honor, if I may, this, what he's referring to, there's a marshal's report of his activities in the Regional Justice Center on April 25th. I believe that's what he's wanting to use to refresh his recollection.
Is it a court, has it been marked?
It has not,
Okay, you wanna, approach and have
Can I see
it
it?
marked?
yes.
So it'll be marked as Defense Exhibit A.
Well, okay. Just using, I don't know that I'm going to admit it, but just to allow him to
Okay.
use it.
No, it's just marked for purposes of identification at this point.
I can continue testifying while we're
Just a
waiting.
minute.
Okay. Just trying to be accommodating.
Okay, again, I told you you're not gonna stop and read these
No, no,
exhibits.
okay.
You need to
Yeah,
be
yeah,
prepared
okay.
to testify.
I'm sorry. Yeah, this is April 25th, 20.
Okay, I'm gonna object to him reading from the
Right,
documentation.
The objection is sustained.
Okay, well, I was there on the 25th of 2019.
So I would request that his counsel remove it if his recollection is refreshed, Your Honor.
Was that the purpose? It was,
To,
because he testified that April 25th he was in there, so.
Can we
I'm not
publish this
sure.
or no? I mean, what's the deal?
well,
I thought this was entered as an exhibit.
the proposed exhibit,
Can't publish this? Because I'll just need another minute to
You
refresh.
can't
my-
publish
take your
exhibits
time,
that
the
have
first
not
time
been
is you
admitted.
need to,
Okay.
remember.
I'm not sure he needed his recollection refreshed. I'm not sure what this document is doing. I mean, he testified that
Okay, I
April
was at,
25th.
Why don't you explain to the jurors?
Okay, I
What
was
is the
at,
document that you're looking at?
yeah, it's a deputy marshal's report.
I'm objecting to this too. This is not in evidence. He can't testify as to what this alleged report says. It looks to me like a Word document I've never seen before.
And it's clearly hearsay.
Okay, I was there at 18 different locations of the RJC that day. One among them was the courtroom 1C, which was about toward the end of the day. I was there for several hours on that day, and that was just one stop. At no time did I know Mr. Federico was gonna be on the bench that day, or pro tem judge Federico was gonna be on the bench that day. I went to the cashier's office to conduct some business. I was in several different courtrooms, and I went to different offices. A lot of the people know me in this courthouse, so I'd say hi to
And
certain
that's,
individuals.
keep
Yeah.
going.
And
That's
so-
not relevant.
So anyway, I go into that courtroom and I see, before I get in, you can see through the crack that he's on the bench. So I go in there and, as I've done many times before to take notes, whether he's on the bench or somebody else. I come to that first row. As you'll note on the video, I've got the gray container with me. I found that it always saves time if I dress or put the other stuff in my pockets while I'm waiting or in line or sitting down. So that's why that gray bucket is there. So I'm hoping to take some notes and see if there's any more misbehavior on Mr. Federico's part, because that's partly what I'm there for, is to see if he's doing any, what I perceive as violations of the Code of Judicial Conduct. And so it appears that he was still talking to somebody. He looks up and he sees me, and he says, "Mr. Blandino," and then that interchange happens, which you all saw on the videotape. And I said, "Are you addressing me?" And he says, so on and so forth. And then says, "Get out, you got 10 seconds. There's that magic 10 seconds again. So he says, "Get out or I'm gonna find you contempt." And at the very end, he says, "Don't stalk people." Now, I got that jabs as well as that transcript. I paid for that transcript of that day and that interchange, because in my mind, as I perceived it, he had no business whatsoever throwing me out of that court room on that day. If he'd have just let me sit there and take my notes, I'd have been there probably through the entire session that he did to see if there was any more impatience or code violations, and that would have been it. So I was completely shocked by that. So I'm familiar with the customer feedback forms that they have, which I referred to earlier in my testimony. So I went right away and got customer feedback forms plus the continuation pages, which you saw the evidence that on a previous exhibit by the prosecution that I attached that. So I got the feedback form. They spent the 15, 20 minutes or whatever it was filling that one out. And then I immediately went home and got on my word processor to craft a letter that goes along with the feedback form, because it's always been my experience that whatever you do on a situation where you're making a complaint or making a compliment, and I did that on feedback forms time to time, is you do it as quick as you can. And since I had the time, I drafted the thing on the Microsoft Word. I don't know how long it took, but you could see it was an extensive letter, or a long letter. So I drove over to the office to drop it off at his office. Now, if he were a permanent judge, I would have dropped it off here at the RJC in the drop boxes that they have. You see those around the courthouse. But he isn't, so I have to go, the only place I go to the office. I mean, it'd be, since I knew he had an office, it's better that than look up what his home address is and write a letter, send it off in the mail. Plus I wanted to see him, have him get that as soon as possible, because, I want to keep coming into the court room and that kind of thing and take notes, as I did with Shannon Nordstrom and Elworth Winter and the other judges that are on those benches as well as on the other benches. So I'm just wanting to resolve this issue. That's my whole intent, is to resolve this issue. If he If he'd have just apologized, say, you know, after thinking later, I shouldn't have kicked you out, then that thing's all done and over with. And then I'm free to do my complaint on the prior thing. You see, the thing is, when he kicked me out, now he can apologize for that, and we can go on from there, but he can't, that incident blows away the possibility of resolving the first incident, the multiple violations we saw at the trial thing beforehand. It's sort of like, in my mind, it's like this. If somebody hits you in the face and you say, hey, could you give me an apology? And then you say, no, I'm not giving an apology, and then they hit you again, then they kind of blew the opportunity to correct with apology the first one. So that's why later on in that proposed resolution, when he asked me to email him all that, unbeknownst to me, the detectives were there. That's why it was only about that issue on kicking me out of court, because the other one had gone by the wayside. He had blown his chance to do that. My religious beliefs and practices only require, to try and resolve it one time. You don't have to go multiple times. Even though I can forgive 100 times, that doesn't mean that you don't take action sometimes. I mean, you can forgive and forget certain things, but then certain other things you forgive, but then you take a certain amount of action, And so therein is my whole thinking. So I go there and drop off that note at his office and with the feedback form. And I figured, well, I just waited to see what would happen at that point. So, I know in prior testimony, they had said that, sorry. Yeah,
Not to,
Right,
talk about other people's testimony.
I'm sorry, I apologize.
It's okay, go ahead.
Okay, so in my mind, it's, I've done my duty to try and get an apology on that second incident, and, I can go forward to try and file the complaint on the first thing before the time limitation. So my recollection, the time limitation runs out, I'm making a complaint for those my perceived violations in the trial setting, so I'm free to do that on that one, and then I can still wait to do any settlement on that second issue where he threw me out of court. Because I was representing to him and that I was an investigative journalist as well as investigating judicial corruption and misconduct. So I was there in both capacities, as well as just my own natural curiosity to see what would happen. So I'm really there in three capacities in my mind. So, let's see. I'm trying to get the chronology straight here. So then it was, that was April 25th. I think I got the call, was it the 29th, 28th or 29th, right? And the thing is, you saw the pictures of my office there. Is there any way we can pull those up on the screen? Because I want to try and give them an idea of where I was exactly when that call came through. And when that call came through, I'll talk as he gets it up there. My call came through, I take an afternoon nap almost every, and he woke me out of a sound sleep. That's why I was shocked at first, because I was still a little bit groggy. Sometimes I get woke up from an afternoon nap and I'm groggy, And so, I know it's been attributed that I was giddy, but I was surprised, giddy, I wasn't happy and surprised because I thought, oh, maybe he's willing to apologize, And so, I put him on speakerphone and I go into the living room. Now, Evelyn Pendergraph is my housemate there. You've heard her name before. And so, she's 96, she's 96 right now, but if we use the back date to the conception like I was talking earlier, she's actually 97. And I've told her that she's gonna make it to 100. I have that on good authority.
Which ones do you want published?
What?
What images would you like?
Oh, well, where they have the pictures of my room, the home office.
Home office?
Yeah.
Okay.
So, in in one of the letters that was sent, I told someone, maybe it was Federico, that I really only have time to virtually eat, sleep, and do legal work, all this work that I'm doing. And you saw that bedroom, I mean, it's the home office. I think the picture reflects that my bed wasn't even made. I mean, the thing is just wall-to-wall paperwork, I mean, almost literally.
Okay, so you have them on speakerphone, you go out to the living room.
Yeah, I go out the living room so that Evie can hear the conversation. And almost the first words out, by my recollection, is, what is it gonna take to get you out of your hair? And that exhibit that showed that is how I wrote it on the pad. I just wanted to wrote it big, and I showed it to Evie, and she, of course, heard it. And she saw that I wrote that. Yeah. Exhibit 1. Oh, okay. So, oh, okay, so this is, the one I'm talking about is exhibit 10.
Okay, do you want Mr. Bateman to publish it?
Yes. And I've got one of those cheapy office chairs you can get at yard sales and stuff. I mean, it was expensive at one point. But I always like to be as inexpensive as possible. So when I get the call, I take my naps usually leaning back and my feet up on the desk and like this. I got kind of a headboard there, so I know it's not the comfortable place to take a nap, but during the day, I'm using that bed oftentimes as I have my papers all spread out. You see how I have my papers like this. I mean, granted, I'm not a very organized person,
all right.
but.
Come on, let's get to the point.
Anyway, so with Evie and the telephone call goes on, and I know I repeated it a couple times. I said, look, if you're not willing to apologize, there's no sense in us even moving forward. I'll just go ahead and make my complaint to the Commission on Judicial Discipline. And so we talk, and I know there's different, he says that,
Again, they heard his testimony.
okay, but he says, what do you want? Do you want me to do something with the
Blandino,
contempt?
Remember, you can say, he made his statements, and then you said what?
Yeah, he said, do you want me to do something with the contempt? And I said clearly, I said, no, if I wanted you to do something with the contempt, that would be either obstruction of justice or meddling with a thing, because I can't influence, and I don't know, similar words, but I can't influence what you did already. You know, I can't change that action. That would be wrong if I ask you to do it, or if you asked me to do it, I said, you need to get an attorney. I mean, but at that point in time, I believe he's being sincere with wanting to resolve things. I have no idea those detectives are in the background, absolutely no idea. And to this day, I believe that God caused me to not realize that, because it looked like a darn sting operation the way the conversation progressed. He was saying these different things like, see, that's the thing, it's 2.5 years. But I repeat over and over again that I just want, I want an apology. But I wanted to meet with him and look at him in the eyes, because talking to a faceless voice over the phone, even though I know the face, you want to judge the sincerity of a person, and that's what I wanted to do, just sit down with him. I didn't have anything planned at all. I didn't have anything with the April 8th visit. That's why I had to borrow a piece of paper. Granted, the second note that I dropped off was typed up because I felt I made the customer feedback form. I'll go straight to my house, type something up, and then take it down there to the office and do it on that same day. I mean, just so he knows that I'm not just the sincerity of my position, on that. And that, I just want to resolve this thing, because I know ultimately I can make a complaint to the Commission on Judicial Discipline. And I've read the different things on the commission and how it works. They don't want you to do this.
Objection, Your Honor.
Sustained.
Well, they advise,
Okay,
I'm
the
sorry.
objection was sustained, so move on, please.
how can I talk as to my perception?
No, the objection was sustained, you need to move on.
I thought I am moving on.
Okay,
My perception is that the commission is concerned.
actually, no, you're not moving on, you're just trying to change the terminology. So the objection was sustained, move on.
Okay, well. I have to try and resolve that with him, so I do my best in setting that off and putting it there, at his office. I get this call, and when he says, and I did not exchange emails, he already had my letters or the emails. He was insistent on, hey, and I may have said, well, I'm gonna have to think about it. But when he did not say, never said, screw you, I'm sorry, excuse my language, go fly a kite, I'm not going to give you any apology or anything. And so I told him specifically that if you're not willing to apologize, there's no sense of me even wasting my time. And so when he gave me that email, and that was at the very last, and that note that I saw, where it says, get you out of your hair, and I wrote that email he gave me carefully on there, so I'd have the email to write. I really believed that he had agreed to that, impliedly agreed that he's willing to at least consider apologizing. Because if I believe that it was not sincere, and later we find out it's just, he's acting with a government sting operation, that he's not sincere, I wouldn't have done anything after that. And in fact, and truth, that if it weren't for my religious beliefs, I would just tell them to go take a hike. But when somebody says, can we settle this? I feel obligated to come back with something. And since I knew I had read all the decisions from beginning to date of the Commission on Judicial Discipline, the different things they imposed on somebody that had violated the code. I knew all those. I had, in doing that thing, I said, well, what I have to do is find a similar type document that, has these kind of settlement things. And so I found one that was approved for Nevada.
Objection.
Sustained. Just tell the jury what you did as a
Okay.
result of that phone call.
I pulled up on the internet a settlement agreement that was about property or something. To this day, I can't find exactly what I pulled up. But all through my life in dealing with the courts and traffic matters or whatever, I have done what a lot of other attorneys do that I have, in my experience, I found out. You do cut, copy, and paste. You're not reinventing the wheel. If you're asking for something from the court.
Okay, so you got on the internet and you got like a sample?
Yeah, a
settlement
sample.
agreement?
Yeah.
And then you did cut and paste?
Cut, copy, and paste, yeah.
Okay.
And so it had that's why it has that 1.1, 1.2, and that format in it. And then I looked to different things like, it was called in the court here, Survivability Clause, because I thought, well, what happens if he dies? And so I'm just anticipating that. In no way did I intend that to be any kind of death threat or implied that I was hoping he'd die or anything, far from it. I mean, I hope that I could put my arm around the guy someday, call him brother. That's my religious beliefs and practices, that anybody, no matter, what road they've traveled their entire life, that's what that reference was to in that letter that I sent. The man in the last 10 seconds of his life, crucified right next to the Savior.
Okay,
yeah.
Mr. Blandino.
Yeah. Anyway, so, I don't have any animus or anything toward people. I always hope that they can find another path if they're heading on the wrong one. And so I'm drafting that thing, and at all times, I'm referring back to these other, Commission on Judicial Discipline. Mostly they did these stipulations where.
Objection.
Sustained.
All right.
Just tell the jury what you did.
Yeah.
So you drafted these settlements?
Yeah, when I drafted those
Okay.
settlements, I was referring to this.
Okay,
And all my experience on that and reading those decisions and seeing what others had done before me in the same situation where there've been violations of the code.
Objection,
the
Your Honor.
objection is sustained. So you did it, and then what?
Did what?
You drafted the settlement agreement, and
Well,
then
no, I'm
what?
still in the process, I'm sorry. That process of drafting that agreement took me over 2 days to do. Now granted, I do it, and then I come back to it, fix dinner or
Okay,
something.
that is not relevant.
Okay. So anyway,
Keep going.
it took over 2 days on and off of going to it, and I felt like under a time pressure because I had told them over the phone I could get back to them in a couple days. And whenever I tell somebody,
Okay,
A
that's
deadline.
not relevant.
I feel like I have to be hold to
That's
that.
not relevant.
Okay. Anyway, so I'm drafting this thing up, and with all that in mind of resolving a legal dispute, because in my mind, if we can't come to anything kind of resolution, I have to file a complaint. I mean, the object was to resolve the situation. And if we met in person, my feeling was we met in person and he apologized, that would have been the end of it. Okay, that would have been the end of it. All I wanted was an apology, basically. But he asked me to do this thing. In looking at all these different decisions and everything, I thought, well, maybe it'd be good for him to take a judicial college course. Or in the alternative, he could pay, my understanding from my research before preparing that.
Objection.
The objection is sustained.
My perception was that the judicial college course cost something like $1,500. And so I thought, well, $500 to the law library, if he didn't have the time or whatever and travel, that might be an alternative. So he does does the judicial college or, the $500. The apology, which I had perceived in past things that complaints commission judicial discipline they've ordered that. They've ordered apologies to the persons affected.
Objection.
The objection is sustained.
Can I ask for some clarification?
No, we can keep testifying.
Well, if he objects, and I don't know on what basis it's
I
sustained.
sustained the objection. It's not relevant.
Oh,
So,
relevance.
Go ahead.
Is there any way I can know what the objection is on?
Mr. Blandino,
Okay.
please keep going.
Alrighty. So anyway, that's what I did in crafting this settlement and release, I think it was the title. Anyway, so I got all that in mind, a fairness aspect. Oh, I had got the $25 for the JAVS, yeah, which actually stands for Jefferson Audio Visual System. Anyway, I got that $25 from Evelyn, and so I felt incumbent on that to be able to reimburse her for that money. Now, the transcript that I ordered of that same hearing, which I actually do have still, I paid for that with my own. I think it was more than actually the JAVS was. So in no way was I trying to make any kind of monetary gain or anything. And if you saw, I mean, what is this, Exhibit 12? I mean, there's a ton of paper there. I mean, this paper took me so much time to, there's legal decisions, all kinds of stuff in there. Oh, yeah, so they could see that, yeah, they should see that.
This is what, Exhibit 12.
Oh, Ben, let me look at that wall, which wall it is. So, there's Marwitz there, so if you're coming in the bedroom, this would be off to the left, the bedroom/office. I got those shelving systems because that room was a total mess before I got that. And I got these plastic containers to put all this paperwork in.
Again, this is not relevant.
Okay, but in any event, this is a ton of paperwork. Let's see, that's the same thing basically from a different view. Well, you've seen this paper. It's just that, I was using this as a bedroom and office, but it was more office than bedroom. So, where was I? Oh, so on the transcript that I ordered, and then the complaint that I subsequently did file on Federico, that thing's about this thick. So there was no way that I was looking to gain anything for myself. This is tremendous amounts of time, effort, energy, and paper and toner on the little broke down printer that I have. I got a little HP 1020. It's about 20 years old.
Okay, again, that's not relevant.
Okay, so, let's see, I just want to look at this exhibit if there was something else to point to here. Oh, yeah, this, Ben. Oh, this is exhibit 26. This is a file folder that they pulled up and taken a picture of. I see that particular folder is judge screw-ups. So it was just my shorthand way of being able to look at a file and see that, and I think Federico was in there, that document all the different places where they violated the code, and in some cases violated the code and violated clear law, which actually also is a violation of the code, is if they fail to uphold clear
Again,
law.
this is not relevant.
Okay,
So you're talking about the agreement you prepared.
Yeah, so the agreement, and then I got it done in the 2 days, I believe it was, and then so I emailed it to the email address that Federico gave me, or temporary judge Federico gave me. So I emailed it to his office. And then, I rushed that thing to get it out to him. Probably, I should have taken more time and done it, because, it's funny, you're looking at judge screw. I made a screw up because
Mr. Blandino, not relevant.
I forgot to, when I emailed that thing, I forgot to give him the exhibits. So that's why I had to, is that the right time frame? I had to re-email with the exhibits. I think that was that part of that. Pretty sure. Hey, Ben, is there any way I can refresh my recollection as to the date on that? What was the date I mailed that, emailed back? Anyway, do you want me to continue so we speed this along? Okay.
Please.
So anyway, you know that I emailed something and then I said, oh shoot, I forgot to attach exhibits. And I'm thinking it's that one. Oh, yeah. Yeah, okay, so this is, yeah, thank you. Okay, so State's Exhibit 5. Yeah, Michael attaches the proposed draft of settlement agreement. If acceptable, you can sign and I can get to your office the same day or next day to sign the same original. Let me know expeditiously. So that was sent on May 2nd, but I screwed up because I forgot to put these exhibits on. And so that's why, what time was this? 8:20 p.m. So I realized, and I was still thinking about everything I had done at that point. So on May 3rd at 3:27 p.m., which is the next day, is, so it's about 20 hours later. I just emailed, rather than just email the exhibits, I don't know what's going on in his office, I just emailed the whole thing all over again. So I did the settlement agreement and the exhibits. Now where I screwed up, that's why it's funny that exhibit was up there, Kim's screw up, was that I forgot to include the provision in this thing that, I meant to have it said that we send this to the Commission on Judicial Discipline, if you agree and I agree, we sign off on it. And that if they wish to adopt any or part of this, they could do it in a published decision. And I just flat forgot to do that. And the other thing I forgot all along the way as, let's see, I'm through with this, Ben. Oh, the first one was Exhibit 5, the May 2 email, and then the other one was Exhibit 6, the follow-up one. What's the one where we, the one where I sent it to the partners, that exhibit? Okay, I'll talk while he's looking for that. Anyway, what I realized is, shoot, he's got, I'd seen his website where it said he's a shareholder, so there's a partnership thing going on. And so in my mind, I thought, I screwed up, I should have sent that from the beginning to the partners. Because, sitting here looking at this and talking to everybody, sometimes I get tunnel vision, I see what's right, and I don't maybe look to the left or the right somehow.
Okay, so then you sent something to the partners?
No, I'm saying that, had I thought about it more clearly, I would have sent this thing to the partners originally, because they would have a right to know. And my thinking is like if, in this regard, and, and the way my mind thinks, oh, this is Exhibit 8, did I say that? Okay, Exhibit 8 is the one where the partners is, and this is the way I looked at it, thinking about it later, is that if I had a daughter and she was married to another man.
Again, this is not relevant.
Well, it goes to state of mind,
It's not
Judge.
relevant.
All right. Well, I just thought that my screw up was it wasn't fair to not send to the partners originally. That's what I should have done. And I could perceive how people could see that, oh, I'm trying to embarrass him or something like that. And nothing could be further from the truth, because if they're all partners, then they got a right to know what's going on and why. And so that there was never any intent to try and embarrass him or anything as a means of forcing him into settling or resolving the issues. And at any point along this line, I mean, to hear Mr. Federico talk about how his wife was afraid, he was afraid for his wife, his kids, and all that kind of thing. It was just completely, I don't even know how that could be figured. If he would have said at any point, buzz off, make your complaint to the Commission on Judicial Discipline, stop coming to my office, at any point along the continuum, he had said anything like that, I'm gone, because this isn't the first letter that I've made. I've made many letters many letters where I said, hey, you violated the code, is there any way we can resolve it? State and federal judges. So I've done this before, and everybody's just basically ignored me. That's one of the reasons I was shocked when he called me. I mean, no one has ever called me before. I mean, now I understand why. I mean, he wants to put me in prison, as I find out by setting up a sting operation with the
Objection,
police.
Your Honor.
Sustained.
I have to strike that
Well-
for the jury not to
And the
consider.
motion to strike is granted.
My point is this, at any point along the line, if he says stop, then I stop, I've had experiences where I've served legal documents on an attorney's office and they'd say, don't come here anymore. You're trespass off the property. From now on, if you want to serve anything in this
And again,
office.
that's not relevant.
So anyway, that was the situation. This was the May 16th, that's right. So this is the May 16th. And then I'm arrested 5 days later at the door on this. But he filed for a TPO in the Justice Court against me. On May 16th, he filled out an application. Can I, with the Justice Court, he filed a TPO against me, an application. I don't find this out until later. Can this be introduced as evidence?
What? I mean,
His application for the
say-
TPO. Is it relevant?
Is it marked?
It is not.
Okay, so then no, it's not marked. Keep going.
Yeah, it's in there. Okay, so he files an application for a TPO. And he tries to get, that's temporary protective order. He files for a temporary protective order, seeking to stop me from coming to his office or even the courtroom. And there was, office, home, or anywhere within whatever the 100 yards or 100 feet or whatever it was. So he didn't get it with a.
Objection, Your Honor. He's gonna get into testimony here about statements made by other people.
Right, yeah, I mean, I didn't understand that that's what you were gonna do, but you already know you can't testify about other people's statements.
Well, I had to defend the TPO. I was in court on the 21st. I was in custody at the time. And the TPO date was, I don't know what date that TPO was. The hearing, let's see. Let me see if I can recollect this. Oh, wait a minute. I was arrested, what did I say?
Okay, I'm not sure the exact date.
Yeah.
Is that important? So,
Okay, well, anyway, I'm in jail and I'm defending against that in justice court. And the judge says, we make our, he does his testimony, I do my testimony, and the judge.
Objection to what the judge says, Your Honor.
Okay. Well, anyway, we're given 30 days to stay away from each other. And if we stay away from each other, they're gonna deny, the TPO is gonna be denied. Okay? And then by that time, I was out of custody on the 30-day return date. So I was out of custody off of the arrest. Now, they have testified to the arrest, right? That I was arrested?
okay, you are testifying, you're not permitted to ask other people questions.
Okay, well, anyway, the judge asks,
Okay, again,
I
you
can't
can't
ask
testify
that,
about
okay.
what
All right.
other people said.
okay, well, I defend against the TPO, and the marshal backs me up. with what I say.
Objection. How is any of this relevant, Your Honor?
The objection is sustained.
Yeah, well, in any event, if this, rather than going through this sting operation with the police where he admits to being government agent, if he had just gone for a TPO or said, just stay away, none of this even happens. None of this happens because I'm just gonna make my complaint. And see, my understanding, my perception is with extortion or bribery, the object is,
Objection, Your Honor.
Sustained.
my objective was to correct misbehavior on the part of a judge. To protect the public from bad judges. And that's what we do when we make public complaints. The judges sometimes make complaints, inmates give complaints, and that's to correct the thing. You're not necessarily trying to punish the judge, you want to correct the behavior so we, as the public, have confidence in that there's good people on the judiciary, on the bench. That was my main intent. And the reason why you might think it's kind of crazy, I had a family court case.
Objection.
The objection is sustained.
I had bad experiences with other judges on multiple occasions and multiple type of venues. And if I had a judge that was behaving properly, then the outcome might have been totally different. I believe it would have been totally different. In my family court case, my
The
son is there.
objection was sustained.
Oh.
Your family court case is not relevant.
All right, okay. In any event, I was driven to do this as a public service. to try and, I wasn't getting any paid, I was, like I said, unpaid, volunteer, I was doing this. And in my statements where I do that, I believe that saying volunteer unpaid meant unofficial. Now, I do put that in there. I put unpaid, volunteer, and then in brackets, which means unofficial, so there can't be any doubt about what my intent is. My intent is to show that I'm doing this on an ongoing basis. It's just not one at a time. I mean, I've got a deliberate plan to try and help the Nevada Commission on Judicial Discipline in that role. I think it's a valuable role. I've written letters to them, said, is there anything I can go to help, to go to the legislature to see that you get money? My investigation showed they get about $1 million a year
Okay,
only.
that is not relevant.
Okay, and in any event, you know, I would have happily done it for no pay, working as an official with them, but I'm unofficial. And so I offered my, my help in whatever way I could, because I think they do very, very important work. It wasn't established in my research until 1977, the commission.
Okay,
Yeah,
this is not relevant, so
Okay.
if you would like to testify about something specific as to this case,
Okay, so, that is what, you know, I did. The, these not relevant stuff always throws me, because now I have to think of where I went next. Okay, so I made I made this last thing, and then that's my last communication. I'm arrested after that. The TPO, and then these charges start in the Justice Court with a criminal complaint. I was served I was served in the jail with, by Peter Marwitz and Kenneth Mead, a notice of intent to indict. In the Justice Court, I was charged only with the.
No objection, Your Honor.
the objection is sustained.
Okay, but anyway, they sent me a notice of intent to indict, and that I could choose to testify if I wished to the grand jury, so I.
How is any of this relevant, Your Honor?
If the objection is sustained, this is not relevant.
Okay. Even if I mailed a notice that I wanted to testify to the grand jury?
This is not
And
relevant.
I'll move to strike that, Your Honor.
The motion is granted.
Okay, so anyway, you know, that's where I am. I'm still, to this day, I'm still representing and I'm investigating. I've made the same type of letters now to other judges that have just abused the
Okay, is there
code.
anything else relevant to this specific case that we're here on?
Yes, I believe so. From that point on, when I saw that was clarity on that, I put that I'm volunteer, unpaid, which means unofficial, so there cannot be any doubt about it. I can understand if some people might think, oh, well, you're trying to claim you're official, but that was never my intent. There was never my intent to extort anyone. This was not any intent whatsoever to extort. And if there was any extortion as a matter of the letter of the law, that was a mistake on my part.
Objection to the letter of the
Sustained.
law and anything like that.
Yeah.
Is it
The
advises
objection is
anything about the law?
sustained.
But anyway, I did not intend to extort. I wanted to resolve a legal dispute. Everything that I had studied on this regard, I made complaints against a federal judge and asked to settle that.
Again, not
Yeah.
relevant.
But everything I had studied on this, this particular issue was that I still retained a right and was not illegal to try and resolve a complaint before I made the complaint specifically to the Commission on
Okay,
Judicial.
Objection.
that will be stricken
Yeah.
from the record.
Mistake of law is not a defense.
Right, so that'll be stricken from the record. Anything else?
Well, I just want to, you know, I'm looking here straight at this jury. And I'm telling you that I did not have any intent to do any crime. I did have no intent to extort Mr. Federico. When he told me that, I told him an apology and he said, well, send me something. It was always about the idea that you could look at it and say, well, go jump in the lake, or, well, what if I just said I apologize? Is that enough? And I would have said, well, yeah, if it's sincere, you look me eye to eye and say, you know, I apologize, maybe I was a little impatient. I shouldn't have done this and I didn't know this, or whatever it might be. Because, you know, forgiveness is part of my DNA, as it were, that, you know, we have to be willing to forgive. And although I really, to this day, and seeing him testify, I think he should find different work.
The objection is sustained.
Anyway, so, I mean, you've seen what I believe reciprocity. I'm ready to apologize when I make a mistake or an error, and I believe it's not improper to ask the same as someone else. And so I just, following what my religious beliefs and practice are, doing to others, you should have them do unto you. Love your neighbors yourself. And so that was all it, is if, and again, if at any time he had said, you know, buzz off, make your complaint or whatever, that would have been done with. And truthfully, he's the only one that ever came back, and everyone else has just, you know, pretty much ignored me. And then I filed my complaint, and in a couple cases, they issued letters of caution to 2 judges. That's what I referenced in that letter. Judge Baird got a letter of caution,
Okay,
and Judge
Dan, this is not.
Herndon got a letter of caution. So I really believe to this point that Paul Dyla and the Commission on Judicial Discipline doesn't want to have something with my name on it.
Objection, relevance.
Right, and now you're starting to repeat yourself, so, the state of Nevada may, question Mr. Blandino.
Thank you. We take a brief recess?
Sure.
Thank you.
All right, during this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors in any way, regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media, read, watch, or listen to the news or media accounts, or commentary about the case, do any research, such as consulting dictionaries, the internet, reference materials, make any investigation, test a theory of the case, recreate any aspect of the case, or in any other way, investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you. We'll be in recess for about, is 10 minutes good?
That should be fine.
Okay, for 10 minutes.
Thank you, all right, for that, Chief Jury.